So, yes, first of all, Mr. Davis is currently in Bell County Jail. Once we start testimony, I can offer into evidence the Bell County Inmate Inquiry Portal page, which shows him being in jail. He's booked in April of this year. Bond is set at 250,000. The charge is aggravated assault with a deadly weapon, and the state understands that the victim is Miss Moore. Um, so, Your Honor, the state is due to his imprisonment, and that is likely going to be longer than 90 days. State is asking the court to set his current child support to zero starting January 1st, 2026. State understands that the children are not on health insurance right now, but that Miss Moore will be getting them on health insurance when she can through her employer. Um, she understands that she wouldn't be able to get any reimbursement from him, and so she's fine with that. Zero cash medical. Um, State has talked to her about considering his charge and stuff. The court would likely make her sole managing conservator, with him having no visitation. Um, State understands that she is not asking for retroactive child support, neither is the state, and the state will also withdraw its request for confirmation of arrears. And state asks the court to portion court costs. And that's about it.
All right, this time, Ms. Moore, raise your right hand, please.
Yes, sir.
Ma'am, you solemnly swear or affirm your testimony gonna give your days the truth, the whole truth, and nothing but the truth to help you.
Yes, sir.
All right, ma'am, you're officially under oath, and I'll go ahead and let the state call you as a witness. Again, ma'am, under these circumstances, the state's gonna ask you questions specifically about the alleged assault of the father community issue, and that will be prima facie as far as the case in this matter is concerned. So I'm gonna go ahead and let them start that, and we'll obviously he's in jail. Obviously, the court's kind of stuck on what I can do, but I can do certain things based on the circumstances that got it there. So at this time, I'm gonna let the state call you as a witness. Thank you.
Thank
Yes,
you, Your
sir.
Honor. State calls Jocelyn Moore. What are the full names of the children in this case?
JC Maurice Moore Davis and Emily Rose Davis.
All right. So for Jason, when was he born?
January 1918.
And then how old is he then?
He's turning 8 in January, so 7 right now.
When was Emily born?
September 10th of 2020.
So how old is she?
She's 5.
And Your Honor, we are adding Emily to the prior order that was done, that was signed on June 11, 2018. All right.
Go ahead and prove they are, and go ahead and prove up that the child is a child of marriage, or that this is the child. All right, thank you. That this is his child. Thank you.
Yes, Your Honor. So, well, Your Honor, I would ask the court. Well, I'd ask the court first to take judicial notice of the acknowledged paternity attached to our pleading.
Oh, okay. Yes. All right, the court will take judicial notice of the pleadings at this time. All right. It's hygiene here. The other one. Okay. There we go. All right, the court will take judicial notice of the court file and Exhibit A, which is the acknowledged paternity that was executed by the parents in this matter for the child Emily. Is it Emily or George? That's one. Okay. All right. The child search name is Emily, and this was executed by both the parties back in September of 2020. This is noting that they are the parents of said child. The court will take that as prima facie based on that AOP that they are the parents, and so fine, and you may proceed. Thank you.
Thank you, Your Honor. Unfortunately, I named my first exhibit, Exhibit A, as the 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 Bell County Jail record. I would ask the court to instead treat it as looks like Exhibit C, and
All
offer it
right.
into evidence.
All right, the court will change this to C, and duly noted, you may proceed. All right, so the court has State's Exhibit C, which shows that Mr. Troy Isaiah Davis is incarcerated in Bell County Jail. It shows what his charge is, his offense date, which was back in April of this year, and that he's in jail on a second-degree felony. The court will duly note that for the record. You may proceed.
Thank you, Your Honor. So Ms. Moore, um, when when is Mr. Davis going to be getting out?
I'm not sure. I believe that he had a court date on the 5th. And the last time that I spoke to anybody, they were saying that they were looking at giving him 25 to life just because of his previous history. So that's all that I'm aware of at this time.
And Your Honor, I have the cause number for the Bell County case. It is 25 DC R9 1722. And it
Right.
looks like on December 12th there's going to be a plea bargain on record.
All right, so that's coming up next week. Court will know that has already noted that it is ag assault with a deadly weapon, and that is a second-degree felony. So, we're looking at 20 years up. So the court will allow you to proceed at this point. Thank you.
Thank you, Your Honor. So Ms. Moore, what health insurance are the children on?
So prior to Troy going to jail, we were supposed to put the kids on his health insurance. So right now I'm just paying out of pocket. But with open enrollment season just passing, I added them on. So I believe what we have is Blue Cross Blue Shield coming up for
And
them.
what is this insurance through? Your employer or
Yes,
something
sir.
else?
My employer.
All right. Do you understand that if the court orders you to provide health insurance through your employer, you won't be able to get any reimbursement for it?
I understand. Yes, sir.
So this alleged crime that he's being tried for, who is the victim of it?
My children and I, along with he had his 3 other kids from his other um, children's mother there as well.
So when did the incident that brought these charges happen?
I want to say it was the day before Easter, or if it counts technically on Easter, because it happened in the early morning to
What
start
what
Easter.
year?
2025.
And so, can you briefly describe to the court what happened?
Um, Troy Davis Jr. was stating that I don't even know how to say it in the courtroom. Like
Just say what it, just say
yeah,
whatever he said.
he was saying that his enemies were coming and they proceeded to pull out guns and wait outside. I locked the door, just thinking that's the only way to protect my children. Troy got mad, came back in the house, and started waving the gun around at all of the children because we were all in his room getting the eggs ready for the Easter egg hunt, and telling us to get out. But we couldn't leave because he was blocking the doorway. So because he kept waving the gun towards the kids, that's what made me call. He wouldn't put the gun down. So I went ahead and called law enforcement, and we were able to be escorted out and explain everything that happened.
Does he have any military or firefighter or police background?
No, sir.
So are you not asking the court for retroactive support?
No, sir.
Well, all right, maybe I'd say that better. are you asking for retroactive support?
No, sir. I don't. He wasn't really supporting me when he did have a job. I'm not expecting nothing from him now. I just need to have this paperwork in place because every time that I did call the police, they were saying it's a common law state, and it was just a lot of legal, I guess, hurdles that I need to make sure I have in place. So no matter what happens, if you go to jail for life or whenever, I don't want to have to deal with this moving forward. I'd rather just get it done.
And is anyone, including him, forcing or coercing you to not ask for retroactive support?
No, sir.
Pass a witness.
All right, ma'am, I'm looking at going ahead and based on these circumstances, even though he hasn't been convicted, the fact that he's been there, looks like he's getting ready to do a plea deal later the next week. And it's going to entail several years in the Texas Department of Criminal Justice. I'm going to go ahead and name you sole managing conservator of the children in this case. Obviously, the fact that he's been in jail for the last 90 days is going to be in jail for a lot longer than 90 days going forward. I'm going to have to go ahead and order zero child support and zero cash medical at this time. You're not requesting retro again. Even if I granted the fact that he may be doing somewhere like 25 years and TJC, yeah, these kids are going to be long grown before that money would ever come to he'd be able to pay it. And I understand why you don't want to ask for it. So I'm not going to order. Those will all be your funds. So I'm not going to order any retroactive child support. I'm going to order that at this time. You're the sole managing conservator. He's a possessory conservator, but he has absolutely no rights under possessory conservatorship until further order of the court. And again, normally I do that once they get out of jail. They can come in and show their terms and conditions of parole and get some type of access. But the fact that he's going to get such a long sentence that's probably not even going to be practical because he may not even be eligible for parole until after these children are emancipated. In other words, they're grown. So at this time, I'm not going to I'm not going to even put that in the order. I'm just going to say he has no rights until further order of the court, and that you have all rights going forward. And as he's in jail, so I'm not going to order him to pay court costs. I'm not going to order you to pay court costs. Is there anything else specifically I need to rule on, Mr. Welch?
Visitation, Your Honor?
No visitation. I want to find that, yeah, well, again, that based on these criminal circumstances, that I'm going to find family violence there, and that the endangerment to the children, and that no visitation is not ordered this time, and is not going to be granted until further order of the court. Anything else, sir?
That's it, Your Honor.
All right, then, ma'am. I'm sorry. Is there anything else you're requesting at this time?
No, sir. Thank you.
All right, Mr. Welch, is the mother excused, or do you need back and break out to review the order and get it signed off on before we get out of here today?
Back and break out, Your Honor. It won't take too long to get this drafted.
All right, Ms. Moore, the state's going to put you back in breakout and send you a copy of this order that gives you all the rights you were talking about. You can go ahead and download a copy of that at that time once you get it by DocuSign, but you will get a final signed order very, very shortly, and that will be your order showing that you have full rights and custody with him having none. Thank you very much, ma'am. Good luck to you and the kids. Y'all hope y'all have a Merry Christmas and a Happy New Year, and we're off the record. Thank you.
Thank you, Your Honor.
All right, the court is taking judicial notice of the court file and note for the record that there is a DNA test report involving Mr. Gates and Ms. McGrew, and it shows that Mr. Gates cannot be excluded as a biological father of the child. Amari Gates' probability of paternity is 99.999999995, and a combined paternity index of looks like 2 trillion to 1. So the court will so find that Mr. Robert Gates is the biological father of the child Amari in this case, and that Mr. and that's prima facie that Mr. Counsel is not. So the court will know for the record that he is not the biological father. And my understanding is that you've got an agreed to order that both parties have signed off on as far as what they're requesting in this matter, correct?
It hasn't been signed off on parties. I have the terms, Your Honor. We're still working on drafting it. All
right, Terry, let's get them on the record confirming that they're in agreement with that, since we're on the record already, and get this done properly then. All right, Ms. McGrew and Mr. Gates, could you both unmute yourselves, turn your video, and raise your right hands, and we'll confirm your agreement, please. All right, thank you both. Do both of you solemnly swear or affirm any testimony you're going to give here today is the truth, the whole truth, and nothing but the truth will help you?
Yes.
All right, you did hear, you can put your hands down. You did hear the court acknowledge that the acknowledgement of that the DNA test shows that Mr. Gates is the biological father, and the state's proceeding with your agreement at this time. You may proceed, Mr. Welch. Thank you.
Thank you, Your Honor. So state calls Christina Cowson or McGrew. What is your full name?
Christina McGrew. Christina Michelle McGrew.
All right. And start off with, do you agree that you and Dad would be appointed joint managing conservator as a child, essentially the default custody arrangement?
Correct.
Do you agree that you would be the parent who has the exclusive right to designate where the child lives, and with that right being unrestricted?
Yes.
And do you agree to Mr. Gates providing the health and dental insurance through his TRICARE?
Yes.
And do you understand it costs him $0 for each?
Correct.
Do you agree to deviate from guideline current child support? Guideline current child support is $619.10, but do you all agree to deviate down to $500 due to the circumstances of Mr. Gates?
Yes.
Are you asking for retroactive child support?
No.
Is anyone forcing you or coercing you to not ask for it? Do you agree to start the current child support of $500 that I mentioned before on January 1st, 2026?
Yes.
And then I'm sorry, I'm more talking to myself. And do you agree to you and Dad doing the standard possession order?
Yes.
Pass the witness.
All right, thank you very much, ma'am. I'll be back in just a moment. Call your next witness, please.
Thank you, Your Honor. State calls Robert Gates Jr. What is your full name?
Robert Samuel Gates Jr.
All right. So do you agree that you and Mom would be named the default custody arrangement joint managing conservators?
Yeah. I don't know what that
Um,
means.
um,
Like we the parents.
Yeah.
That's Texas's
Okay.
version of custody, child support, and visitation, sir. It just named you officially as the co-parents. All right, thank you.
Okay. Yeah.
And do you agree that Mom would choose where the child lives, primary residence, basically, and that you'd pay support?
Yes.
Do you agree to Mom being able to choose be able to choose the child's residence without regard to, well, put it this way. Are you fine with Mom being able to move the child where she wants?
Yes.
Do you agree to put the child on your TRICARE for health and dental insurance?
He already is.
And do you agree for the court to basically keep that arrangement?
Yes.
And how much does it cost for the health and dental?
Don't know about the health. The dental is $29.98.
Are you well,
It's in the LES that I sent to Mr. Hudson.
I see. So you don't know how much it costs for the health, but you do know how much for the dental?
Right. It's the only one that lists actually lists what it is. I'm assuming that their healthcare is wrapped up in mine.
All right. Well, Your Honor, I don't know what it would be with giving him
It's
credit of
not,
$29.98.
it's not there.
It's the same.
The reason it's not listed is because it's you know, all inclusive with his, only the dental is listed. So yeah, that's, and we're deviating, so it doesn't matter.
All right. And sir, are you okay? Are you okay with do you agree to pay $500 per month starting January 1st, 2026 for current child support?
Yes.
And do you agree to you and mom for the visitation to do the standard possession order?
Yes.
Pass the witness.
All right, folks, I'm looking at going ahead and granting your agreement. I've already found that you are the father, Mr. Gates. I'm going to order child support in the amount of $500, which is a deviation down from 600 and some change. But since it's in that 10-15%, well, it's less than 20% deviation, I'll go ahead and grant it based on these circumstances. I'll go ahead and grant, name y'all both joint managing conservator, give mom the right to decide domicile. That right is unrestricted. I'll go ahead and order the child support, order you to maintain the health insurance and the dental going forward until further order of the court, give you the standard visitation package as required by Texas law, and I'll waive court costs due to military service. So at this time, Mr. Gates, do you have any questions or anything else you think I need to know, sir?
No, sir.
Okay, Ms. McGrew, anything else, ma'am?
No.
All right, Mr. Welch, I'll go ahead and grant this as in default of the presumed father. May the parties be excused, or you need them back in breakout to sign off on anything, sir?
Your Honor, they can be excused. I'll send them the DocuSign, or someone will send them the DocuSign for this. So.
All right, folks, you're free to go, and good luck to both of you. And we all have a Merry Christmas and a Happy New Year, and take care of that little boy, okay?
Thank you as
Thank
well.
you, you too.
All right, good luck now, folks, and we're off the record.
Thank you, Your Honor. Oh, Mr. Gates, Miss McGrew, you don't need to say it. Definitely don't need to say it here. But did someone confirm your email phone number?
Yes.
Mr. Hudson should have mine.
All right. And in that case, we're good. I will get that order drafted, send it to you by tomorrow morning, if not today. And then if I can call if needed. So that's y'all are free to leave.
Okay, thank you.
Your Honor, what the state is seeking today is a finalization of the temporary order. There are no contested issues. The NCP and CP were both served. NCP waived service on this back in October of this year. He was sent notice by mail. That notice came back undeliverable, but CP is present today and ready to move forward with finalization of the temporary order.
All right, thank you very much. Mr. Zeno, you there, ma'am?
Yes.
All right, man, I know as ridiculous as this sound, I need you to go ahead and raise your right hand, and I'm going to swear you in. So at this time, ma'am,
Okay.
do you solemnly swear or affirm me testimony you're going to give here today is the truth, the whole truth, and nothing but the truth so help you?
Yes, sir.
All right, ma'am, you're officially on the oath, and I'll allow the state to go ahead and proceed.
Thank you, Your Honor. Mr.
Just
Zeno, when
just
you're
a second, I'm sorry, just a second. Linda, what was that? I'm sorry, we're double checking something real quick. I'll be right back with you. I'm gonna pause the matter just a second.
Yes.
Oh, okay, there it is. Okay. Ms. Gustafson on this one? She was that light in there back in
Your Honor, she was dismissed off of this case back on the second temporary order, I believe.
okay. All right, I got a further temporary order from December 2023. She was there originally. This is the order that dismissed her.
In February, Judge, I believe, is on the second temporary order.
All right, I got a further temporary order. Let's see. Okay. All All right, that was the original temporary order in this matter was back in 2023 on 12/1. And there was a referral, and then there was a further temporary order in December 2023. Has there been one since then?
No, Your Honor. Your Honor, my understanding is there are two temporary orders in this case.
Okay. Okay, and then Ms. Gustafson signed off on this order from 2023. Is this the one that actually dismissed her as their item on it? Because
I'm trying to find that right now.
okay, that's what I was going.
Your Honor, this is one where I'm showing on my notes on my end that on March 7th that a final hearing was done, but a final order was not submitted.
Okay, let me get back to the old docket sheets. Let's see. Oh, okay, yeah, we did. All right, then on 3/7/2024, we did a default hearing. NCP failed to appear at Light present, and all right, that's okay, and that's when we did a final order approving this. We did child support. Let's see, CSO code child support going from 220. CSO. All right, so child support was set at 225 at that hearing, cash medical at 57. A retroactive judgment of $6,920 was ordered in for retroactive child support repayment $85, and no cost. I'm sorry, cost to NCP, no cost to CP, and that item approved. Agreed to that. So what I really need, Mr. Hudson, is just an order. That order.
Certainly. Well, yeah. Well, yeah, I see that now. I wasn't aware that there had been a final hearing on this. I'll get you an order, Judge.
All right, and Ms. Gustafson could sign off on that. And that order saying that 30 days after I sign it, she's no longer obviously the headliner. Mr. Zano, there was actually we're just now luckily my sister. That's why I hate that they always put a new docket sheet every time, and if you don't look back, you miss stuff. So yeah. Luckily my assistant caught it. Man, we've already done a final hearing, and the state's going to prepare that order based on that March hearing and send it out to you and allow to review and sign off on it. And I'm going to sign off on it, and obviously that starts a certain date, so he's going to owe you all that money since that date of that date that the court rendered that order. Now that portion from that time frame to the day is not enforceable by contempt. In other words, I can't throw him in jail for if he didn't pay it. But going forward after I sign it, if he doesn't pay any of those amounts, then he can be thrown in jail, and he still owes you the money no matter what. So at this time, Mr. Zano, do you have any questions, ma'am?
No, sir.
All right, then we're gonna get you a final order, ma'am, to get you done and get you out of here, and hopefully everybody will have a great and happy New Year. All right, so. So at this time, Mr. Hudson may, Mr. Zano may excuse, and
absolutely, Judge, absolutely.
And ma'am, you can be expecting that final order to come through by DocuSign ASAP. Thank you.
Are we off the record, Judge?
I'm getting ready to go off the record, right? And we're off the record. Thank you.
I'm requesting a final order to finalize the temporary order. The issues that the state is concerned with have already been resolved in the temporary order, Your Honor. The only thing that remains is the possession and access, which I believe that Miss Lambert will probably be better at talking about. Thank you, Your Honor.
All right, thank you. So at this time, Ms. Lambert, I'll ask for your opening. Thank you.
Thank you, Your Honor. In the further temporary order, the court has supervised visits only. That was as a result of the father having a pending family in Travis County. The court asked us to reset, seeing if that case is going to come to resolution. I believe Mr. Salas thought that it would, or that it would be dismissed. However, as of yesterday, it looks like there isn't a specific date set on the charge itself, but it has been scheduled for counseling and monitoring for January 2026. So I would be in agreement with finalizing with the supervised visits in place, with the understanding that if this case is resolved sometime soon or the charges are dismissed, that Mr. Salas can petition to modify the possession or the parents can come up with their own visitation plan. I'm hesitant to be a proponent of further temporary orders, only because this has already been going on since 2024, and I don't know that it will resolve soon to let it keep remaining on the court's docket.
All right, yeah, this is the case where they keep kicking the can down the road on the criminal matter. I'm sorry, this is one of the dozen cases I have where they keep kicking the can down the road on the criminal matter. So yeah, so all right then. So let's get some testimony from the parties and see what we're looking at. Because again, right now that sounds having to keep coming back over and over again, put the burden on the father to get either a dismissal notice or an update on his circumstances once it's all taken care of. So at this time, Mr. Solis and Ms. Moore, can you both unmute yourselves, turn your videos, and raise your right hand? All right, do you both solemnly swear or affirm your testimony you're going to give here today is the truth, the whole truth, and nothing but the truth so help you?
Yes.
Yes.
All right, you're both officially under oath. I'll allow the state to proceed at this time. So at this time, Ms. Betzel, you can call your first witness and proceed.
Yes, Your Honor. I'll call Tiara Moore. Ms. Moore, will you state your name?
Tyara Moore.
I'm sorry, Tiara Moore. Apologize for mispronouncing your name.
You're fine.
But as far as the temporary orders go, are you in agreement with maintaining the temporary order as is and making that a final?
Yes.
So the child support and the retroactive payment and the cash medical support are all okay with you?
Yes.
Okay. I'll pass the witness, Your Honor.
All right, Ms. Adlida.
Thank you. Ms. Moore, currently the visits that are included for the temporary order are supervised. Is that correct?
Yes.
And do you believe that those visits remaining supervised would be in the child's best interest until there's a resolution to the criminal case pending in Travis County?
Yes.
No further questions, Your Honor.
All right, thank you very much. Ms. Betzel, call your next witness.
I'll call Jesse Salas, Your Honor.
All right.
Mr. Salas, will you state your name?
Jesse Salas.
Okay. Are you in agreement with making the temporary order a final as far as the child support, the medical support, and the retroactive child support?
Yes.
I'll pass the witness, Your Honor.
All right, Ms. Adlida.
Thank you. Mr. Salas, do you have any disagreement with the visits remaining supervised until your family violence case is resolved in Travis County?
I do not.
And so you would be in agreement to finalizing the order as is today, with the understanding that when that case is resolved, you can petition the court to modify and or expand your visitation?
Yes, ma'am, that's correct.
Thank you. No further questions, Your Honor.
All right, folks, obviously, to keep y'all having to come back over and over again and me having to keep hearing, making y'all come back over and over again, I'm willing to go ahead and grant this order at this time and make the temporary order final. Mr. Salas, again, my apologies, sir, but I was thinking this was a Bell County case. If I know it was a Travis County case, y'all only have what, 800,000 more people than we have in Bell County, so it's going to take, that case might be a while in the finishing up. So I'll go ahead and grant the temporary order and make it final. And once you have a final disposition of that case, sir, you have the absolute right at that point to refile or get someone to file for you to update the circumstances. But again, anything that comes out in the final order down there that may affect this would need to be reviewed at that time. And until that's the case, the court's going to go ahead and keep everything as is. So, sir, since this affects you the most adversely, I'm going to ask you, do you have any other questions about this order, sir?
No, sir.
All right, ma'am, do you have any other questions?
No, sir.
All right, Ms. Bethel, I'll ask you to go ahead and prepare that order and circulate it by DocuSign to the ad litem and the parties. Anything else from the state? You're muted, ma'am.
Sorry, Judge. I think one thing was not addressed in the order, and it is the court costs.
Okay, well, based on these circumstances, if there's court costs billed by the county, I will go ahead and order that Mr. Salas have to pay that, but I'm going to give him till December 31st of next year, 2026, if he gets that bill to pay that. And that's left up to the county to send it over, sir. So if you don't get anything, you don't have to worry about it. But if you do, then that cost will fall upon you, sir. And that's usually somewhere between $300 and $800. It just depends on what the county's going to bill you for. But again, a lot of times they don't even do that. So is there anything else as far as that matter is concerned, Ms. Besson?
No, Your Honor.
All right. Anything else concerning anything that this order is going to dispose of, ma'am?
I think I'm good, Your Honor. If the parties could go back to the breakout rooms though, so that I can draft it and send it out. That'd be great.
Ms. Lambert, anything else from that letter?
No, Your Honor, thank you.
All right, thank you all very much. Everybody have a Merry Christmas, safe Christmas, Happy New Year, and everybody take care. We're off the record.
Thank you as well.
So the court said today, as a pretrial, and it's all in the temporary order. That's why I was saying it was a pretrial. I've talked with the parties. State understands that Miss Brown, she is not. Let's see. She is. She's not going to ask anyone to testify for her, other than I guess, other than the parties themselves at the final hearing. And then she may want to submit some evidence to the court, and but that was something she'll have to do on her own. I've talked with Mr. Foley. State understands that he wishes to have multiple witnesses at the final. I have a list of the ones that he wanted. Ashley Orr, his sister, LaMonica Love, his cousin, Yolanda Orr, his aunt, Corby Orr, his cousin, and I believe he mentioned about a few previous employers, but he didn't give any names. And he also wants to submit to the court documentation as evidence as well. All the state's asking for, Your Honor, is to set this for the final hearing date. And then, if we could try to, at least with the witnesses, figure that out now instead of arguing about it when we come back, so that when we come back, we can immediately do our testimony. That's it, Your Honor.
All right, with that many witnesses, I'm probably looking at making this a live hearing. There's no way to do that easily by Zoom, especially with a lay person as the party requesting the witness's testimony. So at this time, Ms. Brown, what city do you live in?
Foley.
All right, Mr. Foley, what city do you live in, sir?
Houston.
All right, Mr. Foley. Mr. Foley, I'm looking at making this a hearing, but I'm looking at making it a live docket hearing. Again, you're not a lawyer, sir, and the court is very, very wary of anybody who's you have the absolute right to be your own lawyer, call your own witnesses, get testimony from them. But trying to do that on Zoom with a layperson who's not familiar with the Texas rules of evidence, the Texas rules of civil procedure, and the Texas Family Code, all which govern how we do things here. I am looking at making this a final, giving you that opportunity to call your witnesses, but I'm looking at making this final hearing one that has to be done live in my courtroom. It's my option on these type of cases, sir. So I'm looking at making it, you have to come to Bell County to do this. It may not seem very fair, but when I have a half dozen to a dozen, somebody telling me they want to call a half dozen to a dozen witnesses, I want them here on the witness stand. I want them here under oath, and I want it done properly. So again, sir, that's what I'm looking at doing. Unfortunately, like I say, you are coming in from Harris County, but that's what I'm looking at doing at this point, sir. So at this time, sir, since you represent yourself, if you wish to make a legal argument on why the court should not do a live hearing, I'll let you go ahead and tell the court why that should be the case at this time, sir.
I don't know if all those witnesses are going to be able to make it to Bell County for a hearing.
Yes, sir.
So I don't know how this is going to be able to work out, Your Honor.
And so where are those witnesses located, sir?
They're all located in Houston as well.
All right, I tell you what, let me look at some court dates coming up and let me look at some Zoom dates I have coming up. And I'll see whether or not I may have to limit the number of witnesses you have, sir. At those, I'm looking for fact witnesses that can testify to specific items that are going to help the court make a legal decision as far as your case is concerned. If there's an old term that is used among lawyers. I first learned it years ago when I asked in the middle of a jury trial. I asked the lawyer who they had coming in on the final days. He said, "Oh, I'm just bringing in the moaners and groaners, so we know there's not very much information will come from them. So so that would take just that one day worth of hearings. So if you're bringing in someone that's got specific information to the circumstances, sir, that's what I'm looking for. Otherwise, I might have to limit you if you're just going to bring in people to say what a great person you are." So, but anyway, let me look at some court dates here. Let's see what I can do to accommodate either a Zoom or a live hearing. And let me go off the record here for a few minutes and look at my calendar. So anyway, folks, I'm gonna go off the record for about 5 minutes, and I'll be right back. Thank you.
Thank you, Your Honor.
All right. What I decided to go ahead and do is go ahead and try to do this on Zoom, but I'm gonna do certain limitations because again, live docket I got a little bit more freedom, but on Zoom I need to keep this a little tighter. So anyway, let me get back on the record and let y'all know what I'm gonna do. All right, everybody, I'm back on the record on 25 DFAM 351,089. That's in the interest of Foley minor child. The court that's already operating under temporary order. Mr. Foley wishes to have numerous witnesses, and Mr. Foley is out of Harris County, Texas. So the court was looking at making this a live docket, but for this time, I'm gonna go ahead and look at making this a final hearing, and I'm looking at going ahead and using Zoom. All right, let me bring that calendar back up. All right, everybody, I'm looking at a 3-hour slot. Since we're going to use Zoom, I go longer on live hearings, but on Zoom I like to narrow them to 3.5 hours. So at this time, I've got the 9:30 slot available on the 14th of January, and I've got the 1:30 slot available on the 14th of January. Ma'am, Ms. Brown, what works best for your schedule, morning or afternoon?
Oh, if you can give me 1 second because I have OB appointments coming up. I'm gonna check right now.
Okay, let's check this for the 14th. And ma'am, also look at the 2 weeks from that date, the 28th. Also, though, that's the other date I have available in January to do this. Okay, thank you. And Mr. Foley, I'll get your information in just a moment too. Thank you, sir.
Oh, Your Honor, I'd also have a question just to get a better understanding, if that's okay, if I can ask.
What's your question, ma'am?
So I'm just trying to get an understanding with witnesses. Is this for basically the child support to be canceled, or is this for him fighting to try to do full custody, or
That's
become
not
the
up to him
code?
totally, ma'am. It's his right to do both, okay? But again, the burden of proof will fall on him why I should do it and why it's in the best interest of the child that I do such. I got a child here that's 5 years old, and the history will rule supreme here, ma'am. Where's this child been for the last 5 years? What support has the father done? Again, ma'am, it's a case by case matter, but that's what I'll be looking at. And obviously, you can have your own witnesses, and the key testimony in these cases are the parents. Okay, you can tell me what's been going on, what's been happening, and he gets to tell me the same thing, and then I get to make a decision. And the decision can be around child support, it can be around custody, it can be around visitation. But here's the deal, man. I'm going to order child support. There's no such thing as canceling child support. The only way to cancel child support is for me to make a finding that this child is not his biological child or adopted child. All right.
Yes, sir. So those days work for me either. I think did you say the 14th?
The 14th at both at 9:30 and 1:30, and the 28th 9:30 at 1:30. So both of those work.
Either one of those days will work for me. I would just have to request off of work. And I would also like to now change that I would like to have witnesses as well.
All right, then. So what I'm going to go ahead and do, folks, I'm going to change that. I'm going to go ahead and set this, since both of y'all haven't witnessed, I'm going to go ahead and set this at 1 o'clock on the 14th, sir. And I'm going to give it 4 hours because, again, lay people. Yes, sir. What's your question?
Your Honor, I actually have something that I have to take care of on that date.
All right. All right, how about the 28th, sir?
That's fine.
How about the 20, ma'am, 28th still good with you?
Yeah, that's fine.
All right, I'm looking at 1 o'clock on the 28th, and I'm going to give you all afternoon. Here's the deal, folks. I'm going to limit the number of witnesses. Again, I'm looking for fact witnesses can tell the court information about decisions that the court has to make based on the circumstances. So again, I'm not looking for witnesses to say what, you know, you don't need to bring everybody from the First Baptist up with you to tell you what a great person you are and a good Christian you are. I need information on, as far as eyewitness testimony as to being a parent, eyewitness testimony as for being your work circumstances, that sort of thing. That'll work to a certain extent, but again, that's not that relevant. Again, I'm looking at setting up custody, visitation, and child support. The child support's the math. Okay, that's a mathematical formula. And sir, here's the deal. Make sure that you have provided the state all this discovery info request on your paperwork, and ma'am, also on yours. There's a request for production for certain documentation that you're supposed to have already turned in. You may not have, you may, but please make sure that's done and turned in. The date is the 9th of December. I'm going to have the state put in the order that you have until, let me look at January. The 9th of January at 5 p.m. to make sure all your discovery requests that have been served on you will be have been submitted to the state as per their request. Look in your order and you'll find in your original motion paperwork, you'll find a motion for request for production, which includes requests for bank account information, pay stubs for the last 2 years, well, for this current year, child 1040s tax returns for the last 2 years. All that needs to be in. And if you haven't done it, then the state can object to you testifying to anything in that in those categories, sir, that you have not provided that information on. So make sure that's done.
Yes, sir.
And I'm going to limit y'all each to everybody can have a total of 4 witnesses. And please tell your witnesses they will not be allowed to sit in the courtroom, the virtual courtroom. They will be in their own breakout rooms because witnesses are not allowed to hear testimony of other witnesses and what the parties testified to. So, 28th, 1 p.m. Mr. Foley, question, sir.
No, sir. I'm listening. I'm taking down everything that I need to take down, Your Honor.
All right. Any questions at this time, sir?
No, sir.
All right. And specifically, sir, for the court's information, what do you request? At this point, what are you requesting, sir?
As far as the evidence?
No, what are you requesting of the court? You don't have pleadings on file, sir. The state filed pleadings. So what are you requesting? Are you requesting a child support deviation? Are you requesting custody? What are you requesting, sir?
Custody.
Okay, so you're going to have to show the court why it's in your child's best interest that I grant custody. And sir, here's the deal. I want to hear testimony where this child has been for the last 5 years, who this child has been with, that sort of circumstances. Because yeah, I get people in all the time to show up for a 5-year-old and request custody and had very little of a relationship with them. And if that's going to be the case, sir, you know the odds are not great in your favor that the court's even going to let you go that far on that one. All right. Again, I have the right to I'm not sure what your circumstances are, but if you've been in the child's life, you got all that information, you will be allowed to give the court that information, sir. All right.
Understood.
All right, then. And ma'am, the same with you. Obviously, I'm looking at the child's 5. I'm looking at the last 4 to 5 years, and we'll figure this one out. So, ma'am, is there anything else that you have any questions at this time?
No.
All right. Thank you both very much. Anyway, at this time, Mr. Welch, I'm going to go ahead and make the special setting for this one on the 28th of January at 1 p.m. And I'll set this from 1 to 5. All right.
Yes, Your Honor.
All right. Is there anything else the state needs?
Nope.
All right, everybody, I'm going to go ahead and make the Zoom code right now. I'm going to send it out to the state, and they'll put this in the reset order. Mr. Welch, I'll let you get them back in the breakout room and start working the reset order, and I'll get you the Zoom code on it in the next 5 minutes. Thank you both very much. And if that turns out to be one of those ice days, so you never know about the 28th of January, obviously you'll be notified of any resets. But for right now, you're set to go. Zoom docket. And I think I said I got to write this down. 4 witnesses each at 1 p.m. Thank you. We're off the record.
Thank you, Your Honor. All right, Mr. Foley, Ms. Brown, I will move these breakout rooms. All right.
All right, let me go ahead and make the Zoom code. I'll be right with y'all.
Alicia Brown, you're gonna go to room. How about 49? And then Mr. Foley, I'm gonna move you to room 50. I've already confirmed your contact information, so you'll get it through your email.
Yes, sir.
Mr. Gaunt is requesting some unreimbursed medical expenses. State does not really want to get involved in that, Your Honor. So if it's just that, if that's his only thing, the state won't object, but we just don't want to be involved. Um, yeah, basically, Your Honor, we saw that corrected final order, and we believe that that's the end of the case. But if you want to do something on unreimbursed medical, and I'm referring, Your Honor, I believe Mr. Gaunt will refer to, let me find the page.
I got the page already. It's page number 3, and the court did specifically hold in advance any making of determination or order on unreimbursed medical expenses. So that portion of it is still out there. Everything else is final, obviously, but not that.
Well,
Is that what you're talking about, Mr. Welch?
yes, Your Honor. That's what I'm talking about. Like I said, if he and you want to do that, then we won't step in the way. We just ask for that be the only thing.
Well, that's the thing I got pecuniary power to deal with. So yes.
And then we'd also ask that Mr. Gaunt write whatever order comes out of this as well.
Okay. Well,
if there is one.
All right then. All right. Well, is the state asking to withdraw from this?
I mean,
this was signed
state's
off
position,
on by
Your Honor.
the state, one of your representatives signed off on this as being the order for them. They signed off on this and it was in on this matter. So is the state trying to, again, withdraw from this circumstance at this point, or what are you asking me to do, Mr. Welch? Again, y'all didn't know it's going to be here today. I got no pleadings. Obviously, y'all didn't have a chance to run your playbook. Late last night because you're watching the same football game I was, but go ahead.
I mean, Your Honor, I guess our belief is that this case is done, that there's been a final order, and that if Mr. Gaunt wants to do unreimbursed medical, that's fine. That would require a motion. It's just that we don't have any interest in this unreimbursed medical, so that's why I'm not objecting to it.
All right, well, I'll go ahead and see what Mr. Gaunt wants to do. If he wants, and let's hear his side. And Mr. Gaunt, they're asking you to take the you're now the quarterback for the LA Chargers. So again, I'm sorry, that game went on way too long last night. Anyway, what do you want to do, Mr. Hubbard? As far as the unreimbursed medical expenses, sir, what are you asking the court to do? And obviously, I held that in advance and made that a separate part, so we could obviously the court can proceed on that because that was part of the original order and everything else was taken care of. It could have been worded just a little bit better. But what are you asking for at this time, sir?
Are you addressing me, Your Honor?
Yes, sir.
Because you said Hubbard.
Yeah, I know. I'm sorry. I was making a football reference.
Maybe there's somebody else. Judge, just short and brief. Number one, my position is not a final order because it doesn't dispose of all claims and controversies. And you had indicated that you wanted to put this in abeyance. The respondent was here at that previous hearing. You had indicated you wanted us to appear. This is the second time we've come up here on something that we're told was not on the docket, but obviously we're here. So that being said, I can submit to the court. I think it's already been e-filed. I don't want to speak for the state, but my client has about $1,500 in unreimbursed medical. One of two things can happen. I can either submit that and let the court take it under advisement. I don't need to necessarily have another hearing on this per se. If the court's stepping out of the way of it and doesn't take a position, so be it. My understanding is it's all private anyway. But that's really the only thing I'm here about. That being said, the exhibit itself is about 90 pages and change. So I can either run it to the court, e-file it, whatever the court would like to do. If the court wishes to entertain live testimony, that's fine. But that's why we were here today. But in the instance of brevity, if the court just wants to take it under review, I can submit the exhibit. It would be a summary of her testimony.
All right, well then go ahead and let's submit that. Well, I can take a look at it, and then I might need her to verify that information in a quick
Okay.
hearing, and I will set that up as a special setting, in the next week or so, where we can get based on your schedule. But again, looks like the state doesn't want part of this thing. So again, unreimbursed medical expenses don't come through them. So well, whatever. But again, and since they set the docket, that's how this happens. So this doesn't go through the court coordinator's office. So I always found that was always a problem I had when I was appearing in this court, because I never got the official notices half the time. So.
Well, Judge, you set this. This was your request. You set
Right.
this. So either way, I'll submit the exhibit. We didn't imagine this date. I'll set the exhibit and send it over if the court would like. Whatever you need me to do.
I'll tell you what, let's go ahead and e-file it, send it over, and I'll take this under advisement, take a look at it, and if everything is there, it's warranted, everything, I'll go ahead and make an appropriate ruling. You say it's only about 1,500, right?
Yeah, I believe so. My
Okay,
apologies to the
we're talking 15,000. Yeah, the judge might want a hearing on that one. Okay.
All right. So if the court wishes to review the exhibit, take it under advisement. That's really all I need, Judge.
All right, let me take it under advisement. Do you have any more court dates with us this month, sir?
Do I? Yeah, probably. If you'll stand by a second, Judge, I can probably tell you that. In fact, that was why we set that's why we, from the court's sua sponte motion is when I set something, the other thing I have today. So yeah, if you'll stand by 1 second, Judge, I'll tell you. I'm not seeing one. Give me 1 second. I'm going through the end of December now.
Yeah, well, end of December, as far as this docket is concerned, is a week from Friday.
No comment.
Everybody's on all these skeleton crew, days, and people with kids, they take off. So
I don't show anything. Hold on. I don't show anything for the month of December remaining. But again, if the court just needs me to appear virtually on a special appearance for something, I can certainly pop in. I don't want to delay this any further.
All right, let's see. Those are all special settings next week, except for.
Well, with all due respect to the court reviews my exhibits. I don't know that we need a special setting, but that's
No,
me.
I was just saying. I was looking for a date you can pop in when you just got a general docket. I can rule for you right at 9 as soon as we get through calling the morning docket. If there's no more,
Judge,
everything.
Let me put it to this way: if the court needs me to get an attorney over there, I can do it. My schedule is a little bit woggity, but I can do it.
All right, Mr. Welch, we don't have any general dockets next week. I know I got Falls County, and I got the recess of commitment docket next week. We don't have any general dockets next week?
No, Your Honor, the next one I'm saying is January 6th.
Yeah, okay, that's what I thought. Tell you what, Dr. Gallo, I'll go ahead and I'm going to set this. Let's see, I got a 9:30 next Thursday at 18th, a special setting. I'm gonna go ahead and send you over a Zoom code for a special setting at 9 a.m. on that date. And that way I'll go ahead and if I find all the paperwork is appropriate, I'll go ahead and make that ruling at that time. If I find all of it, if I get a chance to look at it this week and I find it's all appropriate, go ahead and make a written ruling, a written finding, I'll go ahead and do that and just send it to you by email. And that way you don't have to appear at that. But I don't want this to fall through the cracks without a setting, okay?
Understood. So you're saying it for virtual 0930 or 0900 on the 18th?
Yes, sir. And anybody can just show up and do that. But hopefully I'll go ahead and get a chance to go ahead and send you a written order, written ruling, and that way you can prepare the order on that and get that taken care of long before the 18th of next week.
Okay, run that back again. You're wanting me to prepare a written order before you've made the order on the 18th?
No, sir. I'm saying I'll go ahead and if I can, I'm gonna go ahead and make a ruling for you long before the 18th, and that way you can go ahead and
understood
the final order. No one has to show up on the 18th.
Understood.
All right. I'm going to make that Zoom call right now, and we're good, and we're off and I'll get ready to go off the record. Is there anything else, sir?
On this matter, I don't believe so. If you'll stand by 1 moment. No, I already addressed another matter. I guess my concern is that I will just say this. The payments are on hold right now because of the order entry. So I know they're busy, but I just wanted to communicate to the court. That was kind of the urgency on my client's behalf.
Well, I'm gonna try to get to it this week. But I don't want to fall through the cracks on you, so I'm gonna go ahead and set that special setting up. And so if push comes to shove, we have that as the fallback. But I don't have anything all day Monday, so I'm hoping that I can come in here and I'll have Belinda put this on the calendar for Monday, and I'm gonna try to get you something out on the 15th. Okay.
Understood, Your Honor. And you
All
do
right.
want me to submit that exhibit, right?
Yes, sir. Yes, sir. I'll definitely
I
need that to make
think
my
it's already
ruling.
been done. If not, I'll either have it run over or I'll have it e-filed.
All right, and I'll be looking for it, sir. Thank you. All right, Mr. Wells.
Understood. Thank you.
Anything else from you, sir?
So when he has it e-filed, we'll get a copy of it.
Yeah,
I wasn't planning on excluding the state.
I'm sorry?
I wasn't planning on excluding the state. They're a party.
All right.
All right, good enough.
I think that's it, Your Honor.
All right, then we're off the record. And Ms. Ferguson, have a great and happy holiday. Don't have too good of a time. Okay, that's my main concern in life. Okay, that no one else has too good of a time other than me. No, just kidding. Have a Merry Christmas and take care, ma'am. Thank you.
Thanks, you too.